Hi, this is attorney and mediator Mike Whalen in Austin, Texas. In this video, I wanted to have a conversation about whether our services are right for your particular case. We believe that if you understand a little bit about who we are, you might be able to make an informed decision about whether our services are best for you. We believe that the way we do things will create confidence, understanding, and empowerment for all of our clients. The first thing I want to talk about is why this conversation even matters. I don't want to get into the weeds of what we do on a particular day to serve our clients. This isn't about process for our sake, but we want you to understand how we do things so that throughout this video you can ask yourself, how will this help me personally? A few things to note. One, we don't practice like everyone else. Number two, not everyone likes the way we practice. But number three, our clients love the way we practice. What I mean by that is we have a pretty specific idea of who we serve, and we've built our business to serve them well. Not everybody's going to be a fit for our business, but if you are a fit, I think you'll be surprised by how much our approach fits your hopes for hiring a good lawyer. So, let's talk about the way we do this, and again, keep in mind as we go through this how this could help you in your particular case. The first thing to understand is that we work in limited scope representation. Basically, what that means is we'll come up with an agreement that outlines very clearly what we do and what it will cost, and then we go do it. It really is that simple. In rare circumstances, situations will change drastically from what we originally talked about. In that case, our clients or the law firm can ask for additional services through a change request. We'll gladly make those changes to adapt to new circumstances, but we never try to sneak things up on you. The change request should only be necessary in extreme circumstances. Generally speaking, you'll know exactly what you're getting into when you start your case. Another interesting thing that we do is to divide our cases into two phases, the negotiation phase and the trial phase. We do this because we find that our initial focus on negotiation can really save a client headaches and money and make co-parenting easier when kids are involved. When we move to the trial phase, being clear on what we're preparing for, a trial, makes us better at what we do. Following these two phases of the negotiation phase and the trial phase gives our clients the greatest chance for getting what they want out of their case. So, the first thing I'd like to talk about is the negotiation phase. The main thing that we're trying to come up with out of a negotiation phase is an agreed final order. We agree in our contract with our clients to do the work necessary to get there, following a specific outline. The outline covers three broad steps in the negotiation phase: drafting and filing the paperwork the court needs to start a case, attending a settlement conference or an informal meeting of the parties to try to resolve things, and then going to a mediation, which is similar to a settlement conference, but with a neutral third party there to help out. Again, I want to note that this negotiation phase will have its own contract with one flat price, and that will cover all the services that we guarantee to try to reach an agreement. We find that about 80% of our cases actually settle during the negotiation phase, which is a rate we're really proud of. If for some reason an agreement can't be reached in the negotiation phase, we'll create a new agreement for the trial phase. So, now, we'd like to talk about the trial phase. By the way, you'll know all of the costs and timelines of a trial before your mediation, so you can make an informed decision about the costs and benefits before sitting down to try to negotiate. So, the trial phase. It's similarly made up of three broad steps. Discovery is the process that lets attorneys basically know what the other side has to show a judge. Trial preparation includes everything from witness preparation to depositions to a trial strategy. And then, of course, you attend a trial where we tell your story in the best way possible. Again, the trial phase requires a second special agreement that will be fleshed out just before mediation in the negotiation phase. This is also a flat fee agreement, though generally much more expensive than the negotiation phase. This is also where the more cliche lawyer work gets done, like the kind of stuff you see on Law & Order. So, now that you know about our process, I hope you're asking the so what question. What you need to know is that we follow a specific process and that we expect our clients to value and participate in that process. Our process is meant to get you the best results possible and make sure you always know what's going on in your case and have the information to make good decisions. And we want you to know that the way we do things truly makes you the owner of your case. It's so important to us that you feel involved and empowered from the beginning, rather than having some attorney who doesn't know you dictating what you should do. We consider your case a collaborative project, and we think our process can make sure you are prepared to make great choices. Again, my name is Mike Whalen with the Whalen Brown Law Firm. You can visit our website at whalenbrown.com. Hopefully, this video will give you an idea of who we are, how we operate, and you can head to our website to find even more about that. Hopefully, you'll know, as you consider us, whether we're the right fit for you. Thank you again for listening to this video.